Another count of theft on the 27th of July 2018, also taken together with the previous one. 10,000 rand fine or 3 months imprisonment, which was fully suspended. Count 4 was of theft as well. 24 July 2018, also taken together with the previous ones. Your Worship, the state begs leave to hand in the SAP 69s for them to be marked as an exhibit. So court pleases.
Indeed, my inference from what the prosecutor placed on record was that it's one case number, counts 1 to 4, 1 and 2 fraud, 3 and 4 theft. Yes, but it was one case.
One case?
Yes.
And then it was, I think altogether it was 276.
That, yeah, correctional supervision. 276 yes.
And that's 12 months.
Correct. That is what I infer from the 69s as well. Thank you, Worship.
I wanted to make that clear. Because there's an implication on between page 2 and 3. SAP 69 is not
as the court pleases, Your Worship. Your Worship, the state would also like to submit that when considering whether it is in the interest of justice that the accused be released on bail or warning, Your Worship, that the court be reminded of the first appearance of the accused before this court. She was asked, Your Worship, she was legally represented, and her legal representative informed the court she had no previous convictions, despite the previous convictions that had been handed to this court. The state is of the view that this shows that the accused was dishonest to the court, Your Worship. And also to inform the court and the accused that the state will be adding a charge of failure to disclose. The court should also take into consideration the assault of 2017. It is a similar charge to the one that the accused faces today, Your Worship. And the investigating officer also mentioned this in his statement, which shows that the accused before court has a propensity of committing offenses, similar offenses in that case. Just after 2017, where she was on a suspended sentence, 2 years later, she finds herself having committed the same offense. This is something that the court should take into consideration when it makes its decision. to that, Your Worship, the state is in possession of an A1 statement, and just to reiterate that the complainant is well known to the accused, and after the incident occurred, there were threats that the accused uttered to the complainant. The state would like to read a short paragraph, Your Worship, to the court. It is A1 statement deposed by Kulu Eliwe. Paragraph 4. My sister Mbali of 46 Salukanda Street, Zamini, heard the noise and then she came out immediately and she took me inside the house to clean myself. I then went to the clinic as my mouth was having a big cut. When I was at the clinic, Makoto followed me and she was insulting me there at the clinic, telling me that she fears nothing and she has the money to bribe the police to drop the case. This is also some information that the state would like the court to take consideration of, Your Worship. The threats that the complainant endured after this incident occurred. With that said, Your Worship, that is the state submissions. As the court pleases.
Court pleases. Your Worship, this is a Schedule 5 offence. It is so that it's incumbent upon the applicant to prove on a balance of probabilities that the interest of justice permits a release on bail. Your Worship, if we look at the papers that have been submitted to yourself, none of the personal circumstances contended by the applicant have been disputed by the state. Moreover, the fact that the accused is of ill health, she's pregnant with twins, she's not getting the medication, much needed medication, and we have adduced evidence in support of this contention. It's not a bold allegation, and this is accepted by the state. I respectfully submit, if I refer you to State versus Hartsleep, State versus Sawela, and I have the full citations of the cases, if whatever the applicant states, and it's prima facie, and if the state does not adduce evidence to contradict and rebut, it becomes conclusive for purposes of this application and these proceedings. I submit with respect, what is it that you can accept? And I'm not going to repeat it. Everything that is said as part and parcel of the personal circumstances. Because it has not been gainsaid. It has not been disputed by the state. More particularly, the defense that the accused, or rather the applicant, has disclosed. It's a bona fide defense. Nothing was adduced from the state side to contradict the prima facie, bona fide defense that the accused has raised. It's a Schedule 5 offense. The merits of the matter is not that important as it is in a Schedule 6. However, it's a factor to be considered. And this is a factor weighing heavily in favor of the applicant. Your Worship, you're dealing here with a matter where the applicant, or rather, this is common course. This incident has transpired between known people 5 years ago. The arrest only took place now. The applicant stated she also filed charges, and it appears to be of assault and theft of a cell phone. Nothing came from it. The state is not disputing it because the state has not adduced any evidence to the contrary. I, however, do not wish to dwell on these aspects. It is clear that the state is not opposing. They placed it on record. The state is not opposing bail. I understand that this honourable court is not a rubber stamp and is still the master of our own proceedings. If I may respond to what my colleague has placed on record. My colleague has placed on record an incident in paragraph 4 of A1 statement, which purports to be a statement deposed to by the complainant. That statement has not been submitted as evidence, first of all. The prosecutors address has no probative value. And I submit this with respect. But even if it had, it has no bearing on what transpired today and what is transpiring today. I respectfully submit that if there were any threats, Your Worship, there's no allegation that something happened to the complainant. If it in fact happened, it is clear and evident that it must have been empty threats. We, in actual fact, vehemently dispute such an allegation, with great respect. Your Worship, with regards to the previous conviction, we dispute that the applicant was dishonest to this Honourable Court. We have provided you with an explanation. Is it an unreasonable explanation? Although she had previous encounters with the law, we're still dealing with a lay person. She has provided you with a plausible explanation. Is there any reason not to accept it? I respectfully submit there is not. Your Worship, does that have a bearing on granting bail? It can never have. Look at, and I submit with great respect, the conduct of the applicant, her pre-arrest conduct. She was phoned. She said, I'm at my house. Or her husband was phoned. She went to Mondia police station. She said, here I am. She's got nothing to hide. She surrendered herself. She did not have to be arrested at her place of residence. How do you anticipate someone's future conduct? By looking at the past conduct. And the past conduct is without any criticism. I respectfully submit. My learned colleague, from what I gather, the investigating officer, although the prosecutor placed on record that they're not opposed to bail, wants to oppose bail on one aspect, that she has committed an offence of a similar nature.
Before we move on, can I interrupt?
Yes, please, Your Worship.
Let's go back to 20 January when you were not counsel.
Yes.
And this court was the attorney of record then said to this court, it is my instructions clearly that the accused then, because it was not over, the accused has no previous conviction. Was not said once, was said multiple times. And when this court then asked the state, do you have a profile or is it a 60 years? The state said no, we do not have that as yet. But it was a conversation between the investigating officer and the state prosecutor, who then said to the investigating officer, who said to the state prosecutor, these indications of previous convictions. The attorney then said to the court that should the investigations not have been finalized by should the SAP 69s not have been that is not my possibility, but she already indicated that she spoke to the accused and the accused was denied. And then we were talking about one previous conviction of 2017.
Yes.
Now the court is in possession of the SAP 69s to talk about the previous conviction.
Your Worship, as you very well know, I was not the legal representative of record.
You are saying to the court now that the applicant was traumatized.
Yeah.
But she went to the Mondia police station to hand herself over. What was her thinking when she handed herself over? What was it in connection with?
Yes.
And she handed herself over on Sunday at 3 o'clock. She appeared on the 20th, that is 19th. She appeared on Monday, the 20th.
Yes,
I cannot remember the time that she appeared on the 20th. Did she forget between the 19th and the 20th? But she had been previous conditions.
Yes. Yes. Your Worship, I think what we're trying to contend in my respectful submission is when she approached the Mondia police station, she actually went there to find out why is it that they were looking for her.
Because nobody was
Yes.
5 years
Now,
ago something.
as a result of the arrest. She never expected that she would be arrested. That is contained in the papers as well. And as a result of the arrest and the subsequent detention, and of course the pregnancy, she started bleeding. That is our contention and my instructions. And I respectfully submit that her version is that she indicated to her then legal representative that she might have, she cannot remember it. And then it was interpreted in terms of my instructions. Yes. Yes.
The legal representative said to this, it is my instructions.
Yes.
From the applicant,
Yes.
she does not have any previous convictions. And the state is not in possession of the SIPC's accounts. The investigating officer is not here. He left.
If I may.
And remember, the accused, upon arrest on Sunday, she is informed what she's supposed to do. So she knew on Sunday she's arrested for assault, and the intent was grievous bodily harm to the complainant.
Yes.
So she knew on Sunday this was what she was arrested for.
Yes. We humbly apologize for what we feel was a misunderstanding at the time.
Okay.
It is so, Your Worship.
So yes. Then the court heard there's a previous conviction in 2017 for also assault to the age. And then today, the 69 shows fraud. What does fraud entail? What's the one word that fraud entails? Dishonesty.
An element of dishonesty.
Dishonesty.
Yes.
What's the element that this entails today?
Yeah.
Dishonesty.
Well, that is now, Your Worship,
So we are now sitting in a position where the personal circumstances, because I
yes,
and she has caused all of this because of her disease.
yes. Your Worship, we're talking about an element of dishonesty if the court does not accept the explanation that the applicant is providing. The remedy, Your Worship, for the state in this instance is, and my colleague has placed it on record, that they're going to add a charge or even open a separate docket for purposes of the disclosure. Yes. Yes, and that will remedy, and that is where the state will find its remedy in the allegations that is proffered. So I beg and I plead to this honourable court on behalf of the applicant to accept or let it not be a bar against the granting of bail, but let us stand then trial on these allegations and let a trial court find whether her version of the events that she's disclosing now is acceptable or not, and not the bail court, and let the court not already, because of that mistake, punish her and refusing bail for the applicant. I respectfully submit, Your Worship, we know State versus Bronco, State versus Atchison, all those well-known decisions, and bail is non-penal in character. And if this honourable court has any remedy or any concern, it can be remedied by manner of the imposition of bail conditions. And I can refer you to State versus Wilkinson. It's the Supreme Court of Appeal decision. I have the full citation with me, where the learned judges indicated that it's a misdirection not to actively consider the imposition of bail conditions and to regard the refusal of bail as an absolute last resort. Your Worship, I hear what you say with regards to the previous convictions. Let's not lose out of sight that the accused stand trial on mere allegations at this stage. She's presumed to be innocent until proven guilty. Allegations that were made more than 5 years ago. Your Worship, with her specific individual circumstances. Can it ever be in the interest of justice, bearing in mind that the state is not opposing bail, be in the interest of justice not to grant the bail? Your Worship, I can carry on and give you lots of case law on various aspects. I simply do not know whether that is in actual fact necessary in the light of my colleague that is not opposing bail.
May I please just ask you?
Yes, please.
Just to put my mind at ease with regards to this decision which has come to my attention. I see was an employer.
That is the indication. What my approach. Your Worship, yes indeed. I can also refer you to paragraph 15.1.2 where it is contended that it is in actual fact that the applicant's employer was involved. Your Worship, I
understand it completely. That's why I'm
Yeah.
asking. It sounded like it was
yes it is. Your Worship, what I perhaps 15.1.2, page number 7. What I'm perhaps, if I may,
I was convicted of fraud in about 2015. I was accused of fraud from my employer because I passed a credit for products that I bought from them and did not let the district manager know. I did not understand.
yes, yeah, I do not know the full details of the nature of the fraud and the theft, because obviously there was theft that was involved as well. But I can perhaps just add, and I submit with respect, that the current charge that she's facing does not consist of an element of dishonesty. I understand what you say with regards to the non-disclosure. However, that charge has not been added yet. It might be a different docket, and if the state then so wish, they can oppose bail on that particular docket. And whether they're simply going to add it as count number 2, we do not know. It might be a misjoinder, I don't know. But that's for the trial court or even the next occasion, the magistrate to decide. And what is also important, that since 2015, or she says 2015, I think the allegation is 2017, if I'm not mistaken. But I think that the applicant makes it clear that she's not certain of the dates.
2017 was the assault.
Yes.
2018 was fraud.
Okay.
Yes.
But ever since,
Driving under the influence was 2019.
yes, ever since she walked the straight and the narrow, that was the last, that's approximately, we're going for 7 years, more than 5 years, 6, 7 years, and that's definitely also something to be considered. She's a well-known person, she's well-known within your community. I'm not going to repeat all the personal circumstances. Your Worship, it will be, unless there's anything else, I am of the respectful submission, in the face of the state not opposing bail, in the face of the contents of the application, as well as the plausible, in my respectful submission, the plausible explanation that has been provided, that the accused discharged herself from the onus that rested upon her. Is there anything else? Thank you.
Your Worship, just one last thing. The state would like to submit that if the court is of the view that the accused did discharge the honors, Then the state will submit that her passport be confiscated and that she not be allowed to travel outside of the country for the duration of the trial. That's all that the state would like to add to that, Your Worship.
Okay, so I need to ask the state the reason for the delay. What is the investigating officer regarding the delay? The incident happened in 2019. I heard counsel say it's from a court case. It seems the matter has been dead. It's not been investigated.
Your Worship, according to the investigating officer, they were unable to trace the accused in this matter, and at that point they were also having difficulty tracing the A1, the complainant. Yes, that is according to the investigating officer.
Seems that the applicant was not difficult to trace. It seems like she's a well-known person, but the complainant I don't know.
Understood, Your Worship. Yes, that is what
So that was the reason for
yes, that's the reason that the investigating officer provided.
And do you know anything about the body?
Nothing about a counter charge, Your Worship. In this docket, nothing about a counter charge.
And A1, that you read the paragraph wrong, that was made in 2019.
Indeed, Your Worship.
So threats that was made, those were made in 2019.
Indeed.
And there has been no contact between the applicant and the complainant since 2019.
Yes, there has been no contact, Your Worship.
Your Worship, yes, thank you for your indulgence. Your Worship, one last aspect. With regards to the passport and travelling documents, you've read, yeah,
I see she travels
she travels, it's part of work purposes and to generate an income. It will be tantamount to denying her the opportunity and the ability to generate. I beg your pardon?
What is this?
The suggestion would be that perhaps she informs the investigating officer of each and every travel that she has outside the boundaries of Gauteng, outside South Africa, and perhaps provide the investigating officer with an itinerary and a copy of the flight ticket. That I am of the respectful submission will remedy any concern that the state might have.
The court is having another concern. You want to bring it up again?
Yes.
The addresses. I also want to
Yes.
have the investigating officer be informed of the situation.
Yes, that's perfect. Thank you, Your Worship. Whenever she moves to the new address as contended in the application, she will, in writing, inform the investigating officer of the position as the court pleases. May I quickly... So the new address is also, it is in the documents. We will just formally inform you that the applicant is intending to move to this particular address. Court pleases.
Court is ready to proceed with judgment. Can be made by seal. is a value judgment of what would be fair and just to all concerned. And secondly, that the interest of justice must be interpreted to include but not be limited to the safety of any person against whom the offence allegedly has been committed. The court will consider whether the applicant, in terms of section 40, subsection 4, and 40 of the Criminal Procedure Act, A, endangered the safety of the public or a specific person, will commit in another Schedule 1 offence, evade a trial or is a flight risk, attempt to influence or intimidate witnesses or conceal or destroy evidence, undermine the criminal justice system or in exceptional circumstances undermine the public peace and security or disturb public order. The court must further weigh up the personal interest of the accused against the interest of the justice, and the interest of justice must be interpreted to include but not be limited to the safety of any person against whom the offence allegedly has been committed. Now, when the court considers subsection 60, subsection 4A, whether there is a likelihood that the applicant, if she's released on bail, will endanger the safety of the public, there was no evidence that indicated today that the applicant, if she's released on bail, will endanger the safety of any member of the public or a particular person, specifically the complainant. There's no evidence that the applicant today will endanger the safety of the complainant, although she knows the complainant. In the 5 years that the matter has been pending or in being investigated, there's been no evidence that the accused or the applicant has endangered the safety of the complainant. Subsection B, whether there's a likelihood that the applicant, if she was released on bail, will attempt to evade her trial. There was no evidence that she will evade her trial after she was contacted by her husband or by the police. She handed herself over to the Mondia police station. There was no indication that she will evade her trial. She has stayed for a period or resided for a period of 27 years in Mondia, so her address is well known. Subsection C, whether there's a likelihood that the applicant, if she's released on bail, will attempt to influence or intimidate the witnesses. There's no evidence today that she will she will attempt to influence or intimidate the witnesses or conceal or destroy the evidence, as in her mind that this case was not even being investigated. Subsection D, where there's a likelihood that the applicant, if she is released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. This matter was conversed with the counsel of the applicant today, with regards to the fact that the applicant today did not disclose in her first appearance her previous convictions. In subsection 8, subsection A, the fact that the accused, knowing it to be false, supplied false information at the time of her arrest or during the bail proceedings. The applicant did not disclose during her first appearance that she had the following previous convictions. In 2009, on the 14th of October, she was convicted of driving under the influence of alcohol, and her sentence was postponed for a period of 2 years. In 2017, on the 29th of September, she was convicted of assault with the intent to do grievous bodily harm and was sentenced to 1,500 rand fine or 3 months imprisonment, which was wholly suspended for a period of 5 years. And in 2018, on the 24th of July, she was sentenced to 2 counts of fraud and 2 counts of theft from her employer and she was sentenced to, in terms of section 2761H of the Criminal Procedure Act, and this was also not declared by the applicant. The state has decided to remedy this is to charge the applicant with a further count instead of just the count of assault with intent to of grievous bodily harm, to also charge the applicant with providing false information during her bail hearing. The council has also stated to the court that this was done during her bail hearing due to the fact that she was traumatized, and she then did not disclose this information to her legal representative. The court has accepted this explanation from the council and from the applicant. And subsection E, where in exceptional circumstances there is the likelihood that the release of the accused or the applicant will disturb the public order or undermine the public peace or security, there's also no evidence of such. Therefore, the court will grant the applicant today bail in the amount of 5,000 rand. Court will make strict bail conditions for the applicant. So would you be taking instructions on the remainder of her case, or are you only instructed for the bail?
For the moment, I will be requested to be excused, but my instructing attorney, Mr. Oosthuizen, will in all probability appear.
Can I, with you, arrange a date for further investigations? He's not wrote.
Yeah, he's not right. So,
can I arrange with you?
More or less, how long will the state?
We are looking at. I don't know if we are ready for copies, or are we doing further investigations?
Investigations are complete.
Further investigations are complete.
What is the procedure? Will it then be postponed for purposes of disclosure? And
yes, we will postpone
so
today for further for copies, and on the next occasions, copies will be given, and then matter will be transferred to a trial.
Approximately 2 weeks.
Suitable.
Any date in 2 weeks' time. If I'm looking at my calendar, if you don't mind. The 11th of February. The date is suitable to Mr. Oosthuizen, sitting next to me.
It is suitable for the court as well.
Court pleases. Thank you, Worship.
Ma'am, you may stand up. The matter is now postponed 11 February 2025 For copies, your bail is set at 5,000 rand. The court is making the following conditions. No contact with the complainant, direct or indirect. You have to inform the investigating officer of your itinerary when you leave the Republic of South Africa. You also have to inform the investigating officer of your date when you change your address and the address which you move to. Do you understand? Thank you. 8:30, court number 2.